Come to order. Without objection, the chair is authorized to declare recess of the committee at any time. This hearing is entitled Legislative Proposals to Reform the Current Data Security and Breach Notification Regulatory Regime. Before we begin, I'd like to thank the witnesses for appearing today. We appreciate your participation and look forward to the discussion. We've got a great crowd today, must have a very, very interesting subject, so thank you all for being here. I now recognize myself for 5 minutes for purposes of delivering an open statement. 48 states, the District of Columbia, Guam, Puerto Rico, and the Virgin Islands have all enacted differing laws requiring private companies to notify individuals of breaches of personal information. For each state, with robust safeguards and requirements in place, there is another with protections that are simply insufficient, creating a regulatory labyrinth that causes compliance nightmares while leaving uncertainty where certainty is needed the most: consumer notification. Not only do these laws only cover certain sectors, the protections vary widely from state to state. It's important to ensure all consumers are afforded better protections and more prompt notifications. Look at my home state of Missouri, where our two largest cities straddle state borders. There's no reason why a consumer sitting in East St. Louis, Illinois, should have greater protections than one sitting less than 10 minutes away in St. Louis. One individual's personal information is no more or less valuable than another's. This is a national problem that requires an immediate national solution, which is why my legislation, developed with the gentlelady from New York, Ms. Maloney, is both timely and necessary. First and foremost, our legislation would create a national security standard for entities that access, maintain, store, or handle personal information while providing flexibility based on an individual company's size, complexity, and sensitivity of the information it maintains. With a responsible federal standard in place, companies will no longer have to spend valuable time tracking a maze of regulations. That time can be better spent actually securing the personal information of their customers and innovating to fight against cybercrime. The draft legislation also includes robust law enforcement and consumer notification regimes. A covered entity has the responsibility to conduct an immediate investigation and take responsible measures to restore the compromised system. If it's determined that the breach has or will cause identity theft, fraud, or economic loss, the breached entity must notify immediately law enforcement. On the consumer side, the bill requires immediate notification without unreasonable delay to any consumer who may be impacted by a breach of his or her personal information. This is a strict timeline that rivals even the most aggressive state laws. After all, it's the consumer that should be front and center in any conversation surrounding the protection of data. Today, we will also examine legislation introduced by the gentleman from North Carolina, Mr. McHenry. His PROTECT Act would establish a new regulatory regime for credit reporting agencies. Mr. McHenry's work on this legislation and on the broader issue of data security and the protection of consumer information has been an integral part of this debate, and we all appreciate his leadership. This isn't a question of if, but when there will be another data security breach, and the personal information of too many consumers will be compromised. Congress will move a product across the finish line. The legislation we consider today aims to foster an environment where consumers are not just protected, but empowered. This is a challenging issue, one that's been seriously debated in Congress for well over a decade, but the time to act has come. It's essential that the industry looks at the bigger picture here and realize the immeasurable benefits data security safeguards and a responsible notification process will have on their customers and businesses. While some of us may experience short-term pain, it will be far outweighed by the long-term gain of delivering meaningful results for the American people. I want to thank my friend from New York, Ms. Maloney, for working with me on this discussion draft, and the gentleman from North Carolina for his diligent work on his legislation as well. We have an excellent panel of witnesses today. I want to thank you for appearing. I look forward to your testimony. The chair now recognizes the gentleman from Missouri, Mr. Clay, the ranking member of the subcommittee, for 5 minutes for an opening statement.
Thank you, Mr. Chairman. I certainly will not take the total 5 minutes, but I want to thank you for holding this hearing. Breaches are a growing problem, and credit reporting agency Equifax just reported one of the largest breaches ever. July 29, 2017, Equifax detects their security breach. Bloomberg reported that regulatory filings show that on August the 1st, Chief Financial Officer John Gamble sold shares worth $946,000, and Joseph Lofgren, president of U.S. Information Solutions, exercised options to dispose of stock worth $584,000. Rodolfo Plotter, president of Workforce Solutions, sold $250,000 worth of stock on August the 2nd. None of the following lists the transactions as being part of 10b5-1 scheduled trading plans. On September the 7th, 2018, Equifax officially announces the security breach to the public. The company directs consumers to a dedicated website to check if they are included in the breach. October the 2nd, 2017, Equifax announces that Forensic Computer Security Mandiant has identified another 2.5 million people whose personally identifiable information has been compromised, taking the number of victims from 143 million to 145.5 million. On March the 1st, 2018, Equifax reported that another 2.4 million Americans were impacted by their already enormous data breach. That brings the total to 147.9 million Americans. We can all agree that consumers in the United States face a data protection crisis. Currently, no federal law requires credit reporting agencies to offer credit freezes, so I look forward to this discussion and working with the chairman and others on this legislation. I thank you, Mr. Chairman, and yield back.
Gentleman yields back. Today we welcome the testimony of Ms. Sarah Cable, Director for the Data Privacy and Security and Assistant Attorney General of the Commonwealth of Massachusetts, Mr. Francis Creighton, President and CEO, Consumer Data Industry Association, Mr. John Miller, Vice President, Global Policy and Law, Information Technology Industry Council, and Mr. Jason Cradaville, Vice President, Financial Services Roundtable. We certainly thank each of you for being here today, and just a quick tutorial on the, for those of you who hadn't been here before, on the microphone system. When you please turn it on when you get ready to speak. The green light will show, and you'll when you get ready to get to the 1 minute mark left to talk, you get 5 to speak. It'll be yellow, and whenever you get that all done, it's red, and about that time I start to raise my gavel. So we'll get along real well today, I'm sure. With that, we want to start with Ms. Cable. Welcome, and you are recognized for 5 minutes.
Thank you, Chairman Luke Meyer, Ranking Member Clay, distinguished members of the subcommittee. I appreciate being here today. My name is Sarah Cable. I'm an Assistant Attorney General with the Massachusetts Attorney General's Office, and I'm the Director of Data Privacy and Security for its Consumer Protection Division. I'm here today on behalf of my office to testify as to our concerns with the discussion draft bill, the Data Acquisition and Technology Accountability and Security Act. My comments today are informed by my office's over decades worth of experience in enforcing the Massachusetts Data Breach Notice Law and data security regulations, which are regarded as among the strongest in the country. This office works hard to use those laws to protect our consumers, and we think that our consumers are better off as a result. We are encouraged that the subcommittee recognizes the critical necessity of data security and breach protections for consumers, and we share this goal. The constant drumbeat of breaches over the last few years affecting some of the largest and most sophisticated companies has brought the issue of data insecurity to the forefront of the public's consciousness. It's clear that more must be done to protect consumers and preserve confidence in the marketplace. Now is not the time to dilute the tools regularly and successfully used by many states, including Massachusetts, to combat this crisis. The subcommittee's first priority should be on enhancing the existing protections consumers have under state law, not minimizing compliance costs for businesses that allow these breaches to occur. While we understand that federal standardization is the thrust of the bill, Congress should not expose American consumers to increased risks as a result of a new, less stringent national standard. In our view, this bill would harm, not help, consumers. It would restrict, not protect or even preserve, the existing authority and role of the state AGs, and it would disregard, not respect, the important role of the states to enact protections they deem appropriate for their own consumers. I want to make my first point concerning the bill's consumer notice provisions. Our view is that the notice provision as drafted will leave consumers in a worse position than the status quo. If preventing consumer harm is the goal of a data breach notice regime, which we think it is, quickly notifying consumers that their data has been compromised must be the first priority. This allows the consumer time to take steps to protect their identity before the hacker or an identity thief uses the breached information against them. The consumer notice standards in this bill is found in Section 4B2 do not protect consumers. They require notice only after the consumer has suffered harm. This is contrary to today's regime, where consumers under most state laws are notified of breaches before the harm occurs. Notifying consumers after the breach after they are already harmed does little for the consumer, and instead, it allows entities to pass the costs of its poor data security onto consumers, and this is unacceptable in our view. Especially unfair because the bill does not clearly authorize any mechanism to remedy this harm, including by not giving clear authority to the state attorney generals to obtain restitution or consumer damages. My second point concerns the proposed enforcement mechanisms of the bill, which make it harder for our office to protect our consumers. The state AGs are the cops on the beat. We've been on the front lines of this problem for over a decade. We use our authority under our consumer protection laws and personal information protection acts to protect our consumers from breaches and hold companies accountable for failing to protect that data. This bill makes it harder for us to do our jobs. Among other problems that I've laid out in my written testimony, the bill does not require entities to notify state AGs of breaches impacting their state's residents. Under Massachusetts law and currently under the law of at least 24 other states, state AGs get direct notice of breaches impacting their residents. And this notice is critical for us because it allows us to understand whether our consumers are impacted and gives us an informed and comprehensive view of the risks that are out there for consumers. Over the last decade, 21,000 data breaches have been reported to the Massachusetts Attorney General's office. There were 3,800 reported last year, and as currently drafted, we would get notified of none of these breaches. We also want to point out that the threshold for federal notice at 5,000 individuals affected, we believe is too high and will fail to capture breaches that have a significant impact in a state. For example, in Massachusetts, less than 1% of the 3,800 breaches last year met this criteria, and indeed 93% of the 3,800 breaches impacted fewer than 100 residents each. So we think this bill would create a significant blind spot for federal or state enforcement of poor security practices by businesses. Thank you.
Okay, thank you for your testimony. Mr. Creighton, you're recognized for 5 minutes.
Thank you. Before discussing the legislation before us today and how it would impact CDIA members and the credit reporting system in general, I'd like to just give a brief context about how credit bureaus help the economy and how we're already regulated. Our credit reporting system today is the envy of the world. It's a main reason we have such a diverse range of lenders and products from which to choose. Without access to a full consumer report, community banks, credit unions, insurance companies, and others won't know how a consumer has handled their obligations unless they already know the customer. Without credit reporting, smaller institutions would not be able to compete against the very largest banks for your business. Credit reports are a check on human bias and assumptions by providing facts that contribute to equitable treatment. CDIA members make possible an accountable and colorblind system. Without it, subjective judgments could replace the facts of creditworthiness. Credit reporting companies are also innovating to solve the problem of the unbanked, thin file, and credit invisible consumers who have not had a chance to participate in the mainstream financial system, a goal shared by many on this committee. Now, the Federal Fair Credit Reporting Act, which governs credit reporting, subjects credit reporting companies to a comprehensive regulatory and consumer protection regime. The FCRA protects privacy, includes criminal penalties for people who abuse the system, mandates the accuracy and completeness of consumer reports, and makes the process transparent for consumers. On data security, under the Gramm-Leach-Bliley Act, the nationwide consumer reporting agencies are subject to the FTC's safeguards rule as non-bank financial institutions. We're also regulated and face enforcement in current law by the states. Contractual obligations from our financial institution customers make sure we meet the requirements of the Federal Financial Institutions Examinations Council. At every level, this is a well-regulated industry. The PROTECT Act, one of the bills before us today, would establish a new FFIEC data security regulator for our companies. We believe that any major change like this would be better informed by the outcome of the Equifax investigation, which is still ongoing by the FTC and the CFPB. The PROTECT Act also establishes a uniform standard for credit freezes. We believe that this is in the best interests of consumers who share the same concerns, whether they live in Missouri or Massachusetts. The patchwork quilt of state laws creates confusion. Every consumer should have the same rights regardless of where they live. The last major provision of the PROTECT Act would be to eliminate the use of Social Security numbers in 2 years. We do not believe that this is a feasible proposal, and we look forward to working with Mr. McHenry and this subcommittee on alternatives and marketplace innovations. We have obligations under the FCRA to ensure maximum possible accuracy, and the SSN is critical to meeting that legal obligation. We use SSNs for the same reasons that government does. They're the only reliable and universal identifier. SSNs help ensure that information is matched with the correct file. There simply is no other identifier currently in existence that gives us the confidence required to meet our statutory obligations. We take our data security responsibilities seriously, especially in light of the breach at Equifax. While the investigation there is not yet completed, as I said, it has put a spotlight on our companies. We know that the most important thing is not how a company responds to a breach, it's preventing the breach in the first place. The chairman's legislation establishes a national standard for both data security and for breach notification. The bill's provisions would allow a company's prudential regulator to enforce these rules, setting up the FTC as the regulator for those without one already, with enforcement by state attorneys general. Since credit bureaus are financial entities under GLBA, they would continue to be subject to the FTC's safeguards rule and to civil penalty authority for violations of the breach notification provision of the bill. The trigger for what constitutes a data breach is well defined. Reasonable risk that the breach of data security has resulted in identity theft, fraud, or economic loss. We are pleased to note that for breaches over 5,000 consumers, credit bureaus can be notified ahead of others, ensuring that we can prepare for the increased volume that a large breach generates. This legislation broadly conforms to the policy goals CDIA members have had for breach notification legislation, and we're pleased to note the different interests who are working together to solve this problem. As the legislative process moves forward on both of these bills, we anticipate that there will be perfecting amendments to improve them, and we look forward to working with the bill's sponsors and other members of the committee on whether and how to reform our data security and breach notification regulatory regimes. I look forward to your questions. Thank you.
Thank you, Mr. Creighton. Mr. Miller, you're recognized for 5 minutes.
Chairman Lukemeyer, Ranking Member Clay, and members of the subcommittee, on behalf of ITI and its member companies, thank you for the opportunity to testify today on the discussion draft of the Data Acquisition and Technology Accountability and Security Act. ITI is a global policy and advocacy organization representing over 60 of the world's leading information and communications technology companies from all corners of the sector, including hardware, software, internet, networking, and services companies. Our members are not only technology solutions providers, but are also stewards of their own sensitive data. As such, we have interests as both covered entities and third parties in advancing federal data security and data breach notification legislation that serves important consumer protection interests. Chairman Lukemeyer and Congresswoman Maloney, I would like to begin my remarks by commending you for the transparent and inclusive process through which you and your staffs have worked to develop the discussion draft. We share your goal of developing a uniform consumer protective data security and breach regime and appreciate the openness with which you have considered our priority issues. Congress and the business community have worked for more than a dozen years to develop a regime that balances the concerns of all stakeholders, and this effort moves us closer to realizing that shared goal. We recognize that compromises must be made to move this effort forward, and we do not wish the perfect to be the enemy of the good. In that spirit of compromise, ITI supports many of the provisions in the discussion draft, but we also offer several recommendations aimed at further improving and clarifying the draft language. ITI developed principles that a data breach law must include to achieve much-needed regulatory clarity and certainty. We are pleased the discussion draft reflects the majority of these principles by preempting the existing patchwork of state laws to reduce consumer confusion and ensure quicker and more consistent notifications, providing an exception for information that is rendered harmless via technology such as encryption, avoiding over-notification by appropriately limiting the definition of personal information to data that can be used to inflict concrete financial harms, acknowledging consumers are not well served by receiving notices from companies they do not recognize, but allowing companies and their third-party vendors to agree on notification responsibility by contract as appropriate, and recognizing criminal penalties are inappropriate for companies who are themselves victims of criminal hacks. Regarding the security provisions in the bill, ITI has long advocated for security approaches that are voluntary, grounded in sound risk management principles and international standards, foster innovation in cybersecurity and data protection, and are scalable for organizations of all sizes and sophistication. Flexibility is key, as a company must be able to protect the information it holds in a manner that is reasonable and appropriate to the nature of its business, resources, and the sensitivity of the data it handles. The security safeguards appear largely consistent with these key security principles, but we are concerned about the multi-layered approach established by the bill, which sets forth an enumerated list of sometimes prescriptive safeguards layered by a reasonable security standard. To help alleviate this concern, we recommend the inclusion of a heightened burden of proof for regulators, which would simply require a more thorough showing that a company who relied on and complied with the government-directed safeguards and yet still suffered a breach nevertheless lacked reasonable security. In addition to this suggestion, my written testimony offers several additional recommendations to improve and clarify the proposed notification regime. I'll briefly highlight a few of these recommendations here. First, the discussion draft requires notification be made immediately and without unreasonable delay. There are several reasons why immediate notification is not only infeasible but often inadvisable. Chief among them is that consumers will be subject to further harm by would-be thieves if the public is alerted to security vulnerabilities prior to their remediation. We recognize the urgency required in notification and recommend utilizing existing language from one of the existing state laws to more effectively balance these considerations. Second, the discussion draft requires third parties to notify covered entities if a breach of personal data has or may have occurred. Our companies deal with a large volume of security incidents daily, and while breaches are frequently suspected, preliminary investigations often reveal no breach occurred. Third parties cannot and should not be expected to notify based on a guess as to whether a breach may have happened. They must be afforded the same opportunity as covered entities to conduct an investigation to determine whether the security incident resulted in a compromise of data. Third, as the definitions are drafted, third parties will simultaneously be considered covered entities in most instances. This is problematic because the discussion draft imposes different requirements on covered entities versus third parties, so the overlapping definitions will subject third parties to divergent sets of requirements for the same activity. The definition of covered entity must be amended to focus on entities that own or license the data. Fourth, the discussion draft permits unlimited civil penalties arising from a single incident. Most data breaches are the result of criminal acts. Organizations can and should do their part to protect consumer data from unauthorized access and acquisition, but uncapped civil penalties are seemingly punitive in nature and not appropriate when an organization has been victimized by criminals or a nation state. Thank you again for the opportunity to share our perspective here today. I look forward to your questions.
Mr. Brunel, thank you so much. Mr. Credible, you're recognized for 5 minutes. You have a very high bar to critique to. Each one of these witnesses so far has stayed right at underneath their 5-minute allotment here. Go.
Mr. Chairman, Ranking Member Clay, and members of the subcommittee, on behalf of the leading banking and payments members of FSR, thank you for having me here today to discuss two proposals closely linked in their goals to improve cybersecurity and the protection of consumers' credit. For companies across the economy, data isn't just a nice thing to have. It's increasingly the engine of modern commerce. For the better part of 13 years, I have been involved in this committee's work on data security legislation. Back in 2005, when I worked for the late Congressman Steve LaTourette, this committee passed his bipartisan legislation, marking the first time a congressional committee directly tackled this issue. Back then, high-profile data breaches grabbed headlines much as they do today, but it was, in many ways, a simpler time. The ability to harness the power of data was confined to the government or the largest, most sophisticated companies. Household budgeting relied on balancing a checkbook, not data aggregation platforms running advanced APIs. And the cloud was simply an object in the sky. While times have certainly changed, some principles remain the same. Over the last 13 years, the financial industry has consistently called for Congress to enact data security legislation that sets strong but flexible and scalable requirements for companies across the economy to protect data and to ensure consumers receive notice of a breach when they are at risk. The proliferation of sensitive consumer data across the economy has only heightened the need for Congress to act. Today, a business with only a few employees and modest resources can obtain the technology or develop an app to allow them to come into contact with millions of pieces of data. The implications of this from a consumer privacy and business ethics perspective are significant. The discussion for policymakers, however, must begin with security. That's why both the PROTECT Act offered by Congressman McHenry and Mr. Chairman, the discussion draft of data security and breach notice legislation you and Congresswoman Maloney have put forward are both so important and timely. The discussion draft of data security legislation is an excellent start and represents the best opportunity I have seen to actually get a bill through the House. I provide a more detailed review of both proposals in my written testimony, but would like to offer a few observations on the Chairman's discussion draft. First, your draft sets a high bar for data security. For the financial sector, this is critical. Underlying our advocacy for federal legislation is the hope that, with the right standard, the number of incidents can actually be reduced. Reaching the right threshold means spelling out a process and risk-based framework for companies to follow. Federal legislation should not expect a small mom-and-pop merchant to deploy the same cyber resources as would their larger counterparts. Your draft sets the right standard while not unduly burdening firms that have little or no exposure to sensitive data. Second, we strongly believe notification to consumers must be tied to an assessment of risk, as the discussion draft makes clear. By that, I mean a breach of commonly available phone book type information or sensitive information that is encrypted should not trigger notice. Notice must be viewed by consumers as a call to action, based on an assessment that the nature of a breach has exposed them to a risk of financial fraud. Over-notification makes us desensitized. I guess most of us are guilty of throwing out yet another breach letter we received in the mail. With this draft, Congress has an opportunity to reframe the importance of breach notification, making receipt of a notice something we as consumers take seriously. Third, the United States has favored a sectoral approach to the regulation of data security, and that approach should be preserved. By that, I mean new legislation should recognize that sectors, including the financial industry, have existing federal obligations to secure data and notify consumers of a breach and not add duplicative responsibilities. Finally, we believe preemption of the patchwork of state laws is the right approach for Congress to take. Few issues better illustrate the need for a uniform federal standard as data breach. That said, I'd be very concerned if the measure before us only amounted to a weak data protection standard. However, as I mentioned, the discussion draft hits the right mark. In conclusion, with the lessons of history as our guide, it's clear that finding consensus is critical if we want to see data security legislation enacted. FSR has worked for many years to help bridge the policy divides that have caused the legislative process to stall in the past. As evidenced by this panel, more stakeholders are at the table today than ever before, ready to work with this committee and others in the interest of seeing a strong piece of consumer protection legislation signed into law. Thank you, Mr. Chairman. Look forward to your questions.
Thank you, Mr. Crandall, and thank all of our witnesses. You guys did a great job, and we certainly appreciate your thoughtful suggestions. And again, we're discussing draft legislation with regards to what we're doing with our particular bill. And so it's a work in progress, and we appreciate your willingness to work with us on that. It's not perfect. We want to try and get it better, and hopefully be something we can implement here down the road. So with that in mind, I appreciate the statistics Ms. Cable gave us, 28,000 breaches in the last 10 years. We've got a crisis on our hand, do we not? It would seem to me that this is, we've got to do something different than what we've done in the past. So I appreciate your comment. Also, when you said data insecurity, that's a new word. I kind of like the way you phrase that, because after 28,000 breaches, we do probably have data insecurity rather than security at this point. So with that, Mr. Creighton, I want to begin the questioning with you. There's been a lot of the conversation around what this discussion draft might mean for credit bureaus. Can you tell us what, if anything, would change for your members if this bill is signed into law? And you've got two bills here today that kind of address a little bit both in your world, so if you don't mind.
Yeah, sure. Your bill, the data security, the data breach notification and security bill, would we're currently subject to the FTC's safeguards rules, and our reading of the bill is that we would continue to be subject to the FTC's safeguards rules, but we would be subject to a new data breach notification standard at the federal level, which currently doesn't exist. Right now, we comply with a series of state laws around the country.
Is that a better deal or worse deal for you?
Well, I think it'd be a better deal for our consumers, for customers, because we're trying to figure out what that we should be complying with at any one moment. If there was one strong standard that we could live up to, consumers would benefit from that.
Okay, very good.
On the PROTECT Act, the biggest change would be the elimination of the use of Social Security numbers in 2 years. We'd like to talk to the committee about that. That would be not something that we think we could work with, but we're interested in how we can innovate and how we can get find another universal identifier. But it would be a very difficult thing to do. We haven't solved that problem yet, and Congress has been studying it for many years. The other thing is it would set a new data security regulator for the credit bureau industry that would be set by the Federal Financial Institutions Examination Council.
Very good, thank you. Mr. Credible, as you know, financial institutions carry a lot of sensitive information for consumers. Some have charged that those institutions which are subject to the Gramm-Leach-Bliley Act have no requirements when it comes to safeguards and notification. Is that accurate?
In a word, no. GLBA.
I like the brevity of that answer, but I'd like a little more explanation.
Of course.
Thank you.
So, in 1999, Congress passed GLBA. In 2000, the banking regulators and the FTC began implementing it. What they implemented were a series of interagency guidance and guidelines establishing information security practices and breach notification. Fundamentally, that guidance was issued as a core element of safety and soundness regulation. Banks are examined to ensure compliance with the guidance, and compliance is demanded. And if compliance is not met, examiners have an extensive set of enforcement tools at their disposal with which they can ensure any financial institution in violation is compliant.
So they're examined at all different levels for compliance with this, are they not?
Yes, sir.
I appreciate that. Thank you very much. Mr. Miller, one of the most discussed elements of the bill deals with the requirements of third parties to notify in case of a breach. I think you discussed this a little bit in your opening statement, but can you give us your thoughts on how those requirements should be structured?
Thank you for the question. Well, there are a couple of aspects of the third-party requirements that I did point out in my testimony could be improved. One of those is with respect to the overlapping requirements between third parties and covered entities. I think this could be tightened up by, I suggested, fixing some of the definitions and focusing on both sets of definitions on what what types of or what's being handled or stored, and using verbs like that is actually very. It really creates a lot of confusion, and in particular, focusing on the covered entity piece on companies that own or license data seems better, certainly to us. With respect to the third party and the notifications themselves, the goal of the bill, we think, should be to provide, of course, meaningful notice to consumers. So the entities with whom the consumers have a relationship, if we're really going to effectuate that goal, should be the ones providing that sort of notice. There are always going to be other parties involved in a breach when we look at today's interconnected ecosystem, but and the bill appropriately provides for those parties to work out the details of how those costs are shared.
Thank you for that. My time is up. I didn't get a chance to discuss this with you, but just to give you a heads up, and hopefully some of the members of the committee will follow up on this. There's some European standards that are being promoted by some of the folks in Europe, and I am not a big fan of letting Europe tell us how to do our business over here. So I'm concerned about that, and I hope that one of our members will follow up with some questions with regards to how you all view those sort of standards, and if some of them are good, some of them are not so good, and which ones we need to be thinking about. So with that, I yield my time is up, and I yield to Mr. Clay, the ranking member, for 5 minutes.
Thank you, Mr. Chairman. Ms. Cable, according to Attorney General Healy, data security and breach notification legislation marked up by this committee last Congress would have drastically undercut your state's data security regulations. Would the concerns raised by AG Healy still apply to the discussion draft under consideration today? And can you explain specifically which Massachusetts safeguards would be undermined if the discussion draft were enacted in its current form?
Thank you for the question. I think I'll say the difference between this bill and prior bills that I think is positive is that it does have a data security minimum standard. In my written testimony, I've included some areas that I think that where that standard can be improved in a way that I think decreases compliance costs for businesses and protects consumers. So putting that aside, the way that this bill changes the status quo in a way that's worse for consumers is, as I mentioned, it doesn't put notice in their hands in time. Mentioned, it doesn't require notification to consumers until after they've been harmed. It also allows the entity to conduct a preliminary investigation as to the scope of the breach and allows them to take remedial steps to secure the information, but puts no outward time for that investigation. And we believe, in our experience, we've certainly seen this creates opportunities for abuse and further delay before consumers are notified. So we think that that is a big departure from current law that does not help consumers at all.
And as the committee considers creating national data security and breach notification standards, can you comment on whether you believe it is critical that we preserve the ability of states to protect their residents from emerging threats to the privacy and security of their data?
It's absolutely critical. Currently, and our office has been actively engaged with our state legislature on improvements and the additional tools that we can use to protect our consumers in light of Equifax. And we're not the only state. I think states have been extremely active after Equifax in taking a look at their security freeze legislation, their data breach and notification legislation. They're doing their jobs. They're doing what states do best, which is being agile, being innovative, and coming up with protections that they think fit their consumers and their consumers' needs. This bill, the preemptive effect of this bill, we think is not in consumers' interests. And one thing I want to point out about the preemption is it currently, as drafted, it preempts any state law, quote, with respect to securing information from unauthorized access or acquisition. It's not limited to securing statutorily defined personal information. There's a big gap between what constitutes information and what constitutes personal information. And in my written testimony, I included some examples of some existing state law that arguably this bill would preempt that have nothing to do with data breach notification or data security. So I think we are not for weaker standards that preempt stronger state. To the extent there is preemption, we think it needs to be narrowly tailored to the precise matters that the bill is addressing, to not tread on other areas.
And Mr. Chairman, I couldn't agree more with the witness. I mean, and she's making the point is why should we weaken current protections under state laws and that have already been enacted instead of us erring on the side of trying to craft this bill in a way that's consistent with the strongest protections of what the states have enacted to this point. I think she makes a great point about that, and hopefully going forward, we as a committee can find some common ground in that area. And that's just a comment to you. I haven't finished yet. But I mean, look, it makes sense that we actually err on the side of giving the strongest protections possible to the American consumer and don't weaken it because we're trying to come up with a national law. Don't make it weaker in order to appease one side or the other. Make it stronger. Anyway, my time is up, and I yield back.
Appreciate the gentleman's comments, and I appreciate Ms. Cable's comments. In fact, the first comment that you made, we are in the process of fixing that as we speak. I think we were aware of that, but we appreciate you bringing that point to us. And again, we want to make sure that we do this in the right way. And to the gentleman's concerns, this is the reason for the draft. is to find ways to come up with better ways of doing things, and we want to hopefully get that done here. Some of the states have got some standards that are not able to be adhered to by everybody, so we want to make sure this is something that everybody can live with. So we may back off the top standard just a little bit to make sure it works, but we're going to try and get this all done. So again, thank you very much. With that, we'll go to the gentleman who is the Vice Chair of the committee, Mr. Rothfuss, Eastern Pennsylvania. He's recognized for 5 minutes.
Thank you, Mr. Chairman. And Mr. Miller, when we look back at the Equifax breach, one of the major questions that stands out is why it took so long to notify the public. Millions of Americans had their personal data compromised, and Equifax knew this, but they were not able to take steps to protect themselves some time after the breach occurred because they were unaware. At the same time, I understand that if a firm has been breached, goes public before any vulnerabilities can be patched, bad actors can continue to exploit gaps in the firm's cyber defenses. What is the best way to strike a balance between prompt notification and thorough corrective action?
Thank you very much for the question. You know, I think you point out how it is a bit of a paradox. We of course want to provide notification as quickly as possible when there's a breach. By the same token, there are a lot of breaches, unfortunately. I mean, I think the chairman mentioned a couple of times already there's a crisis of sorts, and not all of those breaches are going to actually result in a breach of consumer data. Organizations have to have the opportunity to conduct an investigation to understand both the scope of the breach and also, in particular, to patch the vulnerability before actually providing notice, particularly public notice to consumers. So that's one of the reasons that we advocate against any type of very strict timelines and certainly against an immediate notification, but rather one that's you know, without undue or unreasonable delay or something like that. Thank you.
Well, you know, the chairman raised the issue of the European situation with their general data protection regulation and the requirement of a notification within 72 hours. Have you had a chance to take a look at that? And also, Mr. Cradaville, I'm just curious what you're thinking on what the Europeans have done. If Mr. Miller, you could comment, then maybe Mr. Cradaville.
Sure, happy to. I have taken a look at the GDPR and that legislation. You know, and I think it points to the importance of really being clear about which notification we're talking about. There actually is not a 72-hour notification provision in the GDPR with respect to consumer notifications. That there is again an without undue delay standard there. There is a 72-hour notification obligation where feasible to regulatory authorities. So again, those are different types of notifications, of course. Thank you.
Congressman, I would align myself with Mr. Miller. I completely agree with what he said. No two breaches are the same. If we've learned anything, it's that fact alone. And it does take companies time to get their arms around the breach and to stop the bleeding, as it were, and also to figure out, as Mr. Miller said, did the breach result in something that is actually of harm to consumers? You know, if what was breached was fully encrypted data that is unusable by the person who exfiltrated it from the system and consumers aren't at risk, does that trigger notice? Should that trigger notice? We would argue that it doesn't. In terms of timing, you know, immediate is arguably an unprecedented concept in terms of speed, certainly among the states. As Mr. Miller said, most rely on some variations on a theme of promptly and without unreasonable delay, and we would suggest that that is probably the best way to strike a balance in federal legislation.
You, in your testimony, you wrote, Congress needs to act to require firms of all shapes and sizes that handle sensitive information to protect the data. Why do you believe that is important that firms of all types that handle sensitive data comply?
Thank you for that question. And what I was getting at, I mentioned in my opening statement, you can be a very small business, and with modest resources, you can get access to the technology to allow you to be processing millions and millions of pieces of consumer data. It's very difficult to say that just based on the size of a company alone should determine how or what data security protections you should have on businesses. That's why the approach in the discussion draft that builds in a flexible and scalable framework that looks at a variety of considerations so that a company can look at itself and make the appropriate decisions based on the type of data that they hold, for example, and how sensitive that data is as to what cyber protections they need to have in place.
And how would the bill appropriately tailor data security obligations for firms of different sizes and different industries without compromising our collective security?
Yeah, it's a great question, and you can look even to our law, Graham-Leach-Bliley, for some reference, and there are parallels with what's in the discussion draft. And as I mentioned, the bill lays out right up front a number of considerations that a firm should take into consideration, such as the size and complexity of the firm, the sensitivity and the type of data it holds, the cost of available products and security. Again, getting to the idea that you want a small firm that really isn't touching personal information or sensitive financial information should not have the same data security obligations as any of my members or large nationwide companies.
Time's expired. Yield back.
Gentleman's time has expired. With that, we go to the gentleman from Texas, Mr. Green. He's recognized. Oh, Mr. Scott. I'm sorry. Okay. The distinguished gentleman from Georgia. He's recognized for 5 minutes. Mr. Scott.
Well, Chairman Lukemeyer, first of all, I want to thank you and Ranking Member Clay for having this very important hearing. Data security is very, very important. It's on the minds of all the American people, and we can do a whole lot better, and we better get to work on it very quickly. And of course, as some of you know, I represent Georgia, the home of the most, unfortunately, drastic cyber attack with a very good company, Equifax, that we're working to kind of get that straight as well. But, Mr. Chairman, I would like to just address my remarks to one of the pieces of legislation we got before the Committee on Data Security, and that's my good friend, Congressman McHenry's PROTECT Act, House Resolution 4028. And I just want to talk that, and I've had a few moments of being able to talk to Representative McHenry about my concerns on this, and that is that in his bill, I found that one of the problems is that it only requires enhanced cybersecurity supervision for larger consumer reporting agencies. And I think it's very important to realize that Americans have lost faith in all of their credit reporting agencies. So only applying these new standards in his bill to just the largest agencies would mean we'd have some agencies that would meet enhanced security standards while others would not. And I wanted to just point that out and see if we cannot build upon that. But more importantly, I want to talk about this organization that we refer to as the FFIEC. And that organization is the Federal Financial Institution Examination Council. And that's where we'll be passing this hot potato to. It is the Interagency Council for Financial Regulators. But I think that this isn't enough. I really think Americans really would want us to go a bit farther. And everyone should be reminded that most Americans don't have a choice about whether credit reporting agencies like Equifax collects information on you. The American people, their data are the products of these companies. And this world of the credit reporting agencies and how this industry worked has been a total mystery to everyone up to this point. And after learning about what is happening, some of the people, American people, feel quite a bit helpless and frustrated on it. So let me just ask you in this panel, with that said, I don't think that the Graham-Leach-Bliley standards in Mr. McHenry's bill go far enough. And I think we should hold the credit reporting agencies to a higher standard than we have. We had the worst data breach in American history, 146 million American families lost very valuable data. And so I was wondering if you all agree with me on this. Maybe Ms. Cagle, would you respond to that?
Absolutely. Thank you for the question. I absolutely agree. In our experience, again, over 10 years, 21,000 data breaches, Equifax is by far the worst, both in terms of size and scope, the sensitivity of the data, and what Equifax is. It's in the very business of protecting this precise data. As the full committee learned, I think a few months ago, our office has sued Equifax law. Putting aside the PROTECT Act and looking at the federal data security proposed legislation, I'll note that it does appear to tie the hands of the state against a future breach by an entity such as Equifax. It's a little unclear, but comparing this bill, if it were to go forward against the status quo, an entity like Equifax would frankly receive a windfall in terms of having one less source of regulators over it, and that would be the states. We don't think that's appropriate at all. We think there's no justification whatsoever, especially in light of Equifax, for that to be the case.
Well, thank you, Ms. Cable. My time is up, Mr. Chairman. I just make note that I look forward to working with Mr. McHenry on this, see if we can apply it to all of the agencies. I think he'll be agreeable to that.
Thank you for your thoughtful work here. Thank you, Mr. Scott. His time has expired. With that, we go to the gentleman from North Carolina, Mr. Pittenger. He's recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this important hearing today. I'd like to thank all of you for being here. It's been very revealing for me. Data security is an essential part of any company. It's a critical part of ensuring that consumers' data is protected and that all customers' information obviously is kept safe. I would like to thank, as a result, Mr. McHenry, Mr. Luetkemeyer, Ms. Maloney for their efforts and hard work on this important legislation. With the ever-present threat of data breaches, many Americans are sick and tired of, frankly, their Social Security numbers being breached and being identified. And I would like to address first Mr. Miller and then Mr. Creighton. What can we do about our Social Security numbers being compromised?
Thank you for the question, Congressman Pittenger. I know that the PROTECT Act discusses Social Security number, the potential for phasing out Social Security numbers. I think if you talk to most security experts, they will tell you that that's a laudable goal, moving away from static universal identifiers. The question, of course, as your question implies, is how do we get there? There are all types of innovative technologies and progress being made around different types of authentication using biometrics, et cetera. I can't sit here today and tell you I have the answer on what the alternative is for protecting or even not using Social Security numbers so much, but I do know that we need to keep looking for other solutions to what Social Security numbers are currently serving in terms of the purpose they are.
Ms. Creighton, would you like to weigh in on this?
Yes, sir. The Social Security number is really used as an identifier, not as an authenticator, and that's an important difference. You would be surprised at how many people in this country share the same name and even share the same date of birth. And the Social Security number gives us the ability to match the right information with the right file. For example, a father and a son who share the same name and maybe even the same address, right? So we believe it's very important that the Social Security number stay out there for identification purposes only. Now, if that was all that was necessary for you to go out and to get a loan, there would be a much greater incidence of new identity fraud or new account fraud in financial institutions because the Social Security number has been compromised so many times that they're out there, right? The OPM hack, which I was subject to, and I'm sure others on this committee were, is one example of many other examples where the Social Security number has already been compromised. The wide-scale usage of Social Security numbers didn't happen overnight, right? It really was something that's a decades-long process that started with the executive branch and eventually moved into the private sector. But now it's there. And the question that I think we need to answer is, if we're going to replace it, what do we replace it with? We still need something that is going to identify people.
And
I don't have the answer for that, and I wish I did. Believe me, because
I knew it was just going to burst out.
oh no, I wish. But I personally have been breached so many times that I really it
Sure.
makes you crazy, right?
I have too.
I understand that, but there is nothing right now that it could be replaced with, unfortunately.
We'll wait for that magic moment.
Yes, sir. Me too.
Mr. Credible, kindly tell me the role again, and just clarify the law enforcement and what they play in determining the notification time frame after a breach has occurred.
Sure, thanks for that question, Congressman. Financial institutions work very, very closely with two primary law enforcement bodies. That would be the Secret Service and the FBI. They very often maintain very close working relationships with field offices so that in the event of a cyber incident, it can be a mutual effort to help ascertain what has happened, get a handle on the breach, and the main purpose of involving law enforcement is to see if they have the capacity in the course of investigating a breach to identify who has done the hacking and maybe even go after them and get them. And you know, that's thinking about it in the context of the timing question that we've talked about for notification, it's very important to let that process happen. Our members take the engagement with law enforcement very, very seriously, and I know having them involved in an investigation is critical.
Mr. Creighton, would you like to weigh in?
Yeah, and in fact, in some cases, law enforcement actually requests that the breached entity not disclose until they can finish their investigation. And that's something that I think the law should probably accommodate as well.
Thank you. My time's expired.
Gentleman, times is about to expire. With that, we go to the gentleman from Washington. Mr. Heck is recognized for 5 minutes.
Thank you, Mr. Chairman. Last night, I had the pleasure of watching my wife, whose birthday is today, her beloved alma mater, Gonzaga University, put the hurt on BYU. Apologies to Congresswoman Love for the WCC championship. This will be our 19th straight trip to the dance under Coach Few, who's the winningest active coach in the NCAA. And many years ago, the big schools started coming after him because of his success. They tried to lure him away with a contract, a multiple, far away from the little Jesuit university in Spokane, Washington. And he kept saying, no, 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 no. And he said, no, 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 ever since. And eventually, they stopped asking. And then reporters started asking, why did you say no all those years? And his response was, why mess with success? And that wisdom reminds me of a provision that is included in this draft bill, and that is the carve-out for state insurance regulators. I want to thank the chair for that. I fought very hard for that last year when we were in the midst of that, and extend my gratitude to Ms. Maloney as well. I think it's a recognition that for those of us who have as a goal protecting consumers, acknowledge that state insurance commissioners oftentimes are doing this very well. I know they are in my state. My goal is protecting consumers, and my insurance commissioner is doing that. But that's not to say, of course, that we don't have significant cyber threats in this area. And so, Sarah, I want to direct this at you, if I may, Ms. Cable. We're having a hearing on data security. So if you could suggest to insurance regulators anything that they might do to strengthen their cybersecurity rules, what comes to your mind?
That's a big question. I think I'll answer it by...
It's a great lead-up, though, don't you?
It is. It is. I think I'll answer it by saying this is not unique to insurance companies, but institutions in general. And to comment on a comment made earlier that most breaches are criminal in nature, that's not been our experience. I think, and I think there's other statistics to back this up, but by far the most breaches we see are a result of human error, because humans are humans. Sometimes companies have fantastic policies and employees just don't follow them. Oftentimes, however, companies do not have good policies, or they have a policy on paper that doesn't actually get implemented. And even criminal breaches, I think we see in the case with Equifax, they result because of a failure to do even basic, take even basic security precautions, such as patching a software that a company knows to be vulnerable. And so, you know, I think the advice to a regulator would be, you know, looking to enhance or enact minimum data security standards is they're critically important, because there is an awful lot of room for improvement. And I think the standards established in Massachusetts, which are similar to the Gramm-Leach-Bliley standards, somewhat similar to proposed in this bill, although again, there are some improvements that we've put forth in our testimony, because it is impossible to stop all breaches, but it is definitely possible to stop a lot of them. Insurance companies handle tremendously sensitive information. Sometimes a company has agents all over the place that they have a hard time getting their arms around in terms of making sure that those agents have secure systems, their computers are secure and whatnot. So I do think data security for insurance companies is critically important. The states have been active in this. We had a resolution against Nationwide Insurance a year or so ago. So I encourage state insurance commissioners to consider minimum security standards. I think it's critically important.
So in the short period of time I have left, and prefacing this question with the disclosure I'm not a lawyer, I note that there is a use of terms like a reasonable risk, economic loss, and unreasonable delay within the notification section of this bill. As it relates to Equifax, I guess I'd be curious, Ms. Cable, if you think 40 days was unreasonable, and does unreasonable delay have any legal meaning?
Thank you for the question. I assume I have time to answer. So we have sued Equifax, and so I'd like to not speak to the specifics on the facts that the delay in the timing of the notification is a claim in our case. But speaking more broadly, Massachusetts is one of those state laws that requires notice. I believe the words are as soon as practicable and without unreasonable delay. It doesn't ascribe an outer limit or initial limit for notice. And I think that's for good reason. Every breach is different. The circumstances are different. There are times that an entity is not in a position, I've never seen an entity in a position to provide immediate notice. However, I have seen entities in a position to provide notice that delay it for their own purposes. And you can imagine the list of purposes that might be there. You know, words such as or unreasonable, lawyers have a good time with those words. Ultimately, it would be up to a judge based on the facts and circumstances. So I think those words are useful, that they provide a flexibility that I think is not a bad thing for consumers, and provides entities the flexibility they need.
Thank you.
Gentleman's time has expired, but that goes to the gentleman from Colorado. Mr. Tipton is recognized for 5 minutes.
Thank you, Mr. Chairman. Appreciate the panel being here. Appreciate Congressman Heck's story. Wish we had a Colorado team that was just winning a championship there as well. But I think he brought up an important point, and I think Ms. Cable pointed to it just a little earlier. Brought up Massachusetts, brought up your state regulators in regards to the insurance industry. And Mr. Cradaville, or maybe Mr. Miller, maybe you'd like to speak to some of the variances that we do see between different states, and maybe speak to why it's important that you'd spoke to in terms of some of your testimony to be able to have some of that harmonization.
Sure, I'll start and hand it to my gentleman, Mr. Miller. So I guess I'll give you some, at least one example on the security side and one example on the notification side and variances within state laws. You know, on the one hand, not too many states have data security laws. Of course, Massachusetts has been a leader in that and certainly has arguably the strongest state law on the books right now. It is as Ms. Cable mentioned, there are many parallels to the Gramm-Leach-Bliley standards for financial institutions in her state's law. But then you look at other states, for example, that have a data security law that is perhaps just a one line, you should have reasonable measures in place to secure data. Right? So that's kind of two ends of the spectrum when you think about data security. On notice, thinking about the question of timing. I know that's an important topic that the committee is considering. As Ms. Cable noted, her state has what is a variation of a standard that is used by the majority of states, which is something promptly without unreasonable delay. Some states have chosen to take and set date-specific timelines, say 30 days, I think is what the majority of states that have chosen to pick a date have decided to use. So again, it sort of speaks to the importance of Congress acting here, is to smooth out, set the right standard, an appropriately high standard for everyone in the country, because it shouldn't matter where you live as to whether or not your data is kept secure.
Thank you. I agree very much with everything Mr. Cradaville said. You know, again, just to reiterate the security point, you know, I think it's been pointed out a couple of different times that, you know, there are some states, such as Massachusetts, that do have high security standards in their state laws, but there are many other states, 30-something, that don't address data security standards at all. So, you know, it depends on your perspective, I suppose, when you look at the discussion draft. You know, I'd like to take the perspective that the discussion draft is appropriately trying to raise all those other 30-something boats up to some type of meaningful, reasonable level for security. And then on the notification front, you know, again, agree that in particular when we're talking about how companies function and have customers in an economy all across the country and the world, you know, their customers are everywhere. It doesn't make a lot of sense that they're going to have varying requirements with respect to whether it was unreasonable or undue delay or 30 days or 45 days. So harmonizing a standard in that regard is really going to improve the purpose of the bill, which is to help consumers.
Right. Mr. Cradaville, maybe you could maybe speak to the point in regards to startups and the private sector businesses. What incentives are in place for them to be able to set up cybersecurity regimes within those businesses to make sure that we do have the ability for notification?
I think increasingly privacy and security is being baked in from the moment the coders sit down and start writing the code to make their new technologies feasible. You know, privacy by design, security by design are starting to become sort of the de facto standard by which entrepreneurs and technologists are building applications. And certainly from our perspective, you know, FSR's members tend to be on the leading edge of wanting to partner with and collaborate with those technology providers. And when that's the case, certainly our members are going to expect that their technology partners are living up to the absolute highest data security requirements.
And does that kind of speak to the point that where we don't want to have one specific regimen in place to be able to allow that innovation in the private sector for some of the different ideas that can maybe then be shared with others?
Yeah, you're absolutely right. Innovation in both cyber and payment security, just as examples, is happening at a tremendous rate. And that's why, you know, I keep pointing back to the need for whatever Congress does in this space to be flexible and scalable. A framework, a process and risk-based framework that allows that innovation to continue. If you mandate technologies, you just drive everybody to try to comply with what standard you've baked into the law. That would probably be not in the best interest of innovation.
Well, thank you. And Mr. Chairman, appreciate you and Ms. Maloney and Mr. McHenry's work on a very complex and tough issue that's going to continue to perplex in some areas, but we'll be able to make some move forward with this legislation. Thank you, and I yield back.
Thank you for your comments. The gentleman's time has expired. That would go to the gentleman from Texas, Mr. Green, recognized for 5 minutes.
Thank you, Mr. Chairman. I thank the ranking member as well. Thank you, the witnesses, for appearing today. Mr. Chairman, I ask unanimous consent to introduce some 21 letters into the record. These are letters from the American Bankers Association to the Financial Services Roundtable to the National Association of Realtors to the U.S. Travel Association, not naming them all. There are many more. With unanimous consent, I ask that they be introduced.
Without objection.
Thank you. And, Mr. Chairman, the ranking member broached, if you will, an area that I'd like to go into. And in so doing, I'd like to lay this predicate. There's an industry perspective on this, and it appears that the retailers, and I'm reading now from the briefing book, have cautioned against replacing state standards with a weaker federal standard. There's also an indication from the intelligence shared that consumer advocates are of the opinion that a national data breach notification standard should not come at the expense of weakening the strongest standards already afforded in other states. So my question is to you, in your opinion, is the discussion draft a floor or a ceiling? And each of you can respond if you like. Well, why don't we start here with a show of hands first? If you think it's a floor, would you kindly raise your hand? And if you don't understand what a floor is, you can raise your hand and then I'll say more. All right, if you think it's a ceiling, raise your hand. Okay, seems to have unanimous consent that it's a ceiling. If you would, let's start with Ms. Gable. Why, in your opinion, is a ceiling appropriate or inappropriate?
Well, our position, perhaps not surprisingly, is a ceiling is inappropriate, particularly in this realm. This is fundamentally drafted as a consumer protection measure. And for a variety of reasons set forth today, and I suspect in the letters that were just submitted into the record, there's a variety of ways this bill offers weaker protections than currently are available to consumers under state law. And in light of Equifax, there appears no reason from our perspective to do so by then preempting states from enacting stronger protections or enforcing the existing strong protections they have. It's really just locking consumers into a weaker set of protections for the foreseeable future at a time when breaches and risks continue to multiply. So we are not in favor of a ceiling of protections.
And your name is Cable, not Gable.
Cable, yes.
Okay, thank you. Let's move on to Mr. Miller. Mr. Miller, I believe you would contend that it is appropriate to have a ceiling. Is that correct?
Yeah, I mean, I guess I would.
Mr. Miller, I'm
Yes.
going to have to ask that you not equivocate,
Okay.
if you would. Are you a ceiling guy or are you a floor guy?
Well, I
Mr.
think
Miller,
the bill
Mr.
tries to
Miller,
be both a floor and a ceiling
well,
in some ways.
but the bill is going to be a ceiling or a floor. It really is. So this may be a time for you to pick sides.
I think we want to have a common notification standard, and I think.
Well,
on
let
the
me ask you
security
another
front,
question, Mr. Miller. Let me go on to another question. Do you think that there should be some language somewhere indicating that if there is a breach, you cannot sell your stock if you are one of the executives? You can't sell your stock before you announce the breach. Should there be such language?
I'm not sure if that language should be in this bill or not, but it certainly seems like a sound securities law.
If you'll note, I said someplace.
Okay.
Okay, some appropriate place, because this is what happened. Right. And if you think that there should be some language, we know that their security laws can deal with it, but should there be some language that specifically says, if there's a breach, you can't sell your stock before you announce the breach?
That seems like reasonable guidance.
Raise your hand if you think that there should be such language. Yeah, raise your hand, please. That's all right. Okay, everybody. So I see that we have one person who did not. Sir, would you explain why you don't think so?
The selling stock based on material non-public information is illegal, and this is under investigation. And if they were aware of a breach and they sold their shares based on that, that's something that the SEC and other federal...
I understand that there are agencies and entities that will look into it, but given that it happened and we can put people on notice, is it so redundant that it would be harmful? Is it superfluous to the extent that it makes no sense? It just seems that it's okay to tell people, if you do this, there's a penalty.
It's already illegal, and I wouldn't have any objection to it.
You wouldn't?
It's already illegal.
Okay. Thank you, Mr. Chairman.
The gentleman's time has expired. With that, we go to another gentleman from Texas, Mr. Williams, recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to the witnesses today that are here. As this committee continues to work to protect American businesses and consumers that are under a constant threat from cyber thieves, as we've seen in the past year, cybersecurity breaches and the loss of personal identifiable information have unfortunately affected hundreds of millions of Americans. Mr. Cradwell, In your testimony, you state that this legislation strikes the appropriate balance by setting a high bar for data protection while providing numerous considerations to ensure a small business that processes or maintains little or no personal information is not burdened with the same expectations as a large entity. As a small business owner myself for over 47 years and a steadfast defender of Main Street, I appreciate what you have to say about that. My question is, what importance does scalability play in ensuring a level playing field for entities of all sizes, and how does this affect consumer protection?
Thank you for that question, Congressman. It's one of the critical aspects that we believe should be included in any federal legislation in this space. Scalability, flexibility, taking into consideration the size and complexity of a business, all has to be weighed in evaluating what cybersecurity resources a company should be deploying. If you are an FSR member, I think there certainly are regulatory expectations that you are investing heavily in cyber defenses. I know just a handful of our members have invested over $1.5 billion a year in cybersecurity defenses. So you juxtapose that against small businesses, perhaps such as your own. When you look at your business, perhaps your employees aren't even coming into contact with sensitive financial information that would be covered under this legislation. It probably goes without saying then you should not be employing the same cybersecurity resources as a national bank, for example.
Okay. Another question for you. In your testimony, you state that legislation should recognize both the danger of alerting hackers to vulnerabilities before they have been remediated and risking potential further harm to customers, and then the risk of confusing or alarming consumers unnecessarily if companies are forced to notify prematurely. So why is that important?
The idea there is that oftentimes when a company discovers that they've been hacked, it's often the case that the hackers are still in their systems. That's why in the legislation it makes clear that hopefully law enforcement is going to be able to be involved in a situation like that, and law enforcement may have an opportunity to trace where that hack is coming from, maybe even to identify who's doing the hacking, in which case you definitely want to be able to allow that process to happen.
Okay. Mr. Creighton, some have proposed limiting the amount and type of data that can be reported about consumers to credit bureaus. My question is, what effect would these types of restrictions have on the accuracy of consumer lending decisions, and how would they affect credit availability, particularly for vulnerable populations?
Thank you for that question. When we collect data, we're trying to collect data that's going to matter for a future lending or other decision. Those kinds of data are what kind of accounts do you have? What's your credit limit? How much credit are you using? Do you pay on time? Those kinds of questions. We're trying to continue to gather more information from other kinds of data furnishers, home renting companies, apartment companies, that kind of thing, cell phone companies, others, so that we can expand the number of people who have thin files. Because if you have a thin file right now and you go to get a loan, they look and they say, well, we don't know enough information about you to know whether you're a good risk or not. So we want to get more of that information, because if we have more of that kind of information, we're going to do a better job of giving lenders what they need so that they can bring people into the regulated financial system, which is, I think, what we're all after.
Good. Another question to you. In your testimony, you stated that credit reporting agencies face only enforcement and not supervisory and examinations by the FTC. So why do you believe that empowering the FFIEC to choose the correct overseer is the proper fix for this regulatory gap?
Yeah, thank you for that question. In the time since I submitted my testimony, what I've learned from my companies is that actually the Consumer Financial Protection Bureau has asserted its authority under UDAP and other provisions to begin examination of credit reporting agencies on cybersecurity. While the GLBA specifically says that cybersecurity is carved out, under UDAP authority, the CFPB has asserted its authority and are now examining at least 2 of our companies.
Okay, thank you for being here, and I yield my remainder of my time back.
The gentleman yields back his time. With that, we go to the gentleman from Georgia, Mr. Loudermilk, is recognized for 5 minutes.
Well, thank you, Mr. Chairman. I appreciate the panel being here today. Mr. Cradaville, as I understand it, the Gramm-Leach-Bliley Act may not explicitly require financial institutions to comply with mandatory federal data security and breach notification requirements, but these requirements are essentially mandatory in practice. Can you explain how that happens?
Yeah, thank you for that question. And yes, sir, I mean, I agree with you. They are mandatory. There is nothing about Gramm-Leach-Bliley's security requirements or notice requirements that are treated as optional. As I mentioned earlier to the chairman, fundamentally, these are safety and soundness standards. They are treated as such for examination purposes. Examiners view compliance with both the security requirements and notice obligations as affirmative duties under safety and soundness regulations, and the examiners themselves have a variety of enforcement tools at their disposal should they find a firm is not living up to either of those obligations.
Okay, I appreciate that. I had my staff ask the Congressional Research Service, and they advised of the same thing, so I just want to make sure that we had a good understanding of that, and I appreciate that. Mr. Miller, we'll talk about the third-party liability issue. I understand both sides of this, this debate, and on one hand, understand and I appreciate the argument that the company that is breached should be responsible for the notification, but on the other hand, are we subjecting the consumers to even more or greater risk by transferring more data to an entity that was just breached? I'm trying to find a good medium there. Can you comment on that?
I just want to make sure I understand your question. You're talking about transfers of more data to a third party
in a
because
third party
of the breach?
situation where there was a breach, but the third party may not have the contact information, and if we require them to actually make the notification, are we not risking the consumer by even sending more data to that third party? And
Absolutely, you know, particularly if the third party is the one who was breached. Probably there are questions regarding security, so sending a bunch of additional information to them seems, you know, questionable.
yeah, and I feel like, I mean, there is some liability there, but then we have that issue. I don't know if anybody else would like to comment on that. If you have feelings, it's just one of those the issues we're struggling with at this point of how do we resolve that if the third party was actually the factor that caused the breach.
I mean, if I could just comment a little bit further on the third party. I mean, it's true. Third parties, again, if we look at business arrangements, particularly of large companies across a variety of industries, they're using third parties for a variety of different purposes. Absolutely. Some of those third parties are small companies. Some of those third parties are large companies that are providing all different types of services. You know, there was one very notorious breach a few years ago where a major company was breached through a third-party HVAC vendor, for instance. So, right. I mean, the most sensible way, it seems, to deal with the apportionment of liability in these types of scenarios is through contractual arrangements between the parties who are free to contract with different parties if they'd like to choose different entities with which to work. And requiring strong security practices in your contracts is certainly something I would advise any party to do.
I appreciate that. That's just one of the issues that I've been struggling with, because I understand that there's some liability there, but also do you provide more information to the entity that was just breached? And dealing with information, I'll throw this out to anyone in the panel in the last few seconds we have. Are we collecting and maintaining too much data? Because the more data you have, or the more data we require through the government to be maintained, the more risky it is if you don't have to protect what you don't have. Anyone want to comment on, are we collecting and maintaining too much data?
I think your point is well stated. If you don't have it, you've automatically reduced the risks to your company. You know, I can't speak to, you know, I know that is extremely valuable to businesses, and it provides benefits to consumers for those businesses to have that data. However, we do see a lot of companies collecting data that is very sensitive for consumers without having a present need for it, or holding on to data for years and years and years when they're not using it. So I do think that is part of the concern. Good data management practices would reduce the amount of data that you're not using, that you don't have
Well, I appreciate that, and I think that would expand also to our government as well.
Very briefly, I was just going to make that same point. This is a problem across the economy in both public and private sector.
Thank you, Mr. Chairman.
Gentleman's time has expired. With that, we go to the gentlelady from Utah. Ms. Love is recognized for 5 minutes.
Okay, thank you. Do the standards for credit bureaus different from the standards for other sectors of the economy? If so, how, why? And I want to get into the European cybersecurity initiatives as just to follow up from the chairman's questions.
Sure. The national credit reporting agencies are subject to the FTC's safeguards rule, which is the rule that applies to, under the Gramm-Leach-Bliley Act, to non-bank financial entities. So there's no data security standard for most companies in the country, but financial institutions have standards. So if you're a bank, you're covered by your prudential regulator, but if you don't have a prudential regulator like the OCC or the Federal Reserve, then you're subject to the FTC's safeguards rule, and the credit bureaus are one kind of company that's subject to that.
Okay, so I guess this is opinion for everyone. I'm interested in the European standards. How do you view these standards? Do you think that these standards are going to be influential? I just wanted to follow up because I think that I agree with the chairman. I would hate to have somebody else dictate what we do. So I just wanted to know what your thoughts were on that. And anyone can answer. I'm just...
I'll kick it off because I'll be very brief. Generally speaking, our reading is that for credit bureaus specifically, there would not be much impact from it because we are collecting, as credit bureaus, very narrow parts of the larger information environment. Again, as I said, we're collecting the do you have credit, how much credit, with whom, do you pay on time, and those sorts of, that sort of information is part of an ongoing business relationship that you have with your lender, right? So if you have a credit card account, that credit card company is reporting that information up, and that would continue even under GDPR. The larger data broker issue would come into, is more implicated by that, and that's not a part of the environment that I generally work in.
Okay.
Thanks for the question. With respect to the GDPR, there are a few different requirements particular to breach. You know, as I mentioned previously, there is a without undue delay standard for consumers, and with respect to notifications to regulatory authorities, there's where feasible, but not later than 72 hours language. You know, I would additionally say, to speak to the chairman's question that he teed up at the outset, it's premature to be looking to the GDPR as a best practice for anything, in my opinion, to the extent that it hasn't been implemented yet. It's going to be implemented this May. There are a lot of questions regarding how certain provisions are going to be implemented, particularly around data breach. So I would say I wouldn't worry too much yet about that particular issue. There are also a variety of cybersecurity standards in Europe that have been proposed that I'll also be happy to get into. But
is it important to keep an eye on that and to kind of look on how that affects?
It's definitely important because, again, all of our companies are global companies doing business globally, so they're going to have to comply with that if they're doing business in Europe or doing business with European citizens. So it's important. I'm just commenting on not looking to something that hasn't yet been implemented to see if it can be implemented as designed. I think it's premature to do that.
Do you have any concerns with the present model? I know you're concerned about, because you don't know how it's going to be, what the reaction is going to be or what the results are going to be. But do you have any concerns with the way that it's set up and what the standards are currently?
Well, again, as a number of witnesses, I think all the witnesses have said at one point or another today, you know, having a very tight timeline for any notification, such as 72 hours, is very problematic. Just because, again, and we can point to lots and lots of high-profile breaches. You can look at some of the government breaches like OPM. It takes months sometimes to even realize there's been a breach and then to figure out what exactly is going on. So 72-hour provision, in many instances, is going to be impossible to comply with.
Do they have that in their standard? They have a 72-hour?
They have a 72-hour for notification to regulators, but not for notification to citizens. That
Huh,
took,
okay.
So
do you have anything that you mentioned, you look like you had something that you wanted to add?
I would just agree with what Mr. Miller, the point he made about it might be a little too early to make any judgment calls on GDPR. I know many of FSR's members are global in nature, and so it is already, there's already a tremendous amount of discussion going on as to how do we come into compliance with this
Thank
and
you.
make that system work.
Thank you, Mr. Chairman. Back.
Gentlelady's time has expired. With that, we go to the gentlelady from New York. Ms. Tenney is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, panel, for this discussion. As we know, obviously, cybersecurity, cyber attacks are becoming, the new way to rob a bank, to rob a store, to rob citizens from the living room. Last year, the New York State Attorney General reported 16% that cybersecurity invasions are up 60%, and more of New York's personal records, in fact, have been tripled since in last year's. Obviously, the Equifax breach was huge for us, with 8 million people in New York State being exposed in the Equifax breach out of about 19 million. Actually, this past January, our own New York State Education Department was also breached. And so these things are certainly of concern. I want to just give a little shout out to a local college in my community, Utica College, has teamed up with the cybersecurity department in our county to try to prevent against these attacks and identify potential risks and weaknesses in our data system. But my question involves, first I'd just like to find out, like, to what extent will a national standard provide for better security than something on the local or state level? I mean, obviously, I'm just curious if you could comment on that. Maybe Mr. Crowderville, you could mention it first.
Sure, thank you very much for the question. If it's done correctly, and by that I mean if it is an appropriately strong standard that, as we've talked about a lot, takes into consideration a variety of factors to not overly burden small businesses, we believe that is the absolute best way for Congress to act to ensure that no matter where you live in the country, that your data is protected with a strong standard. That is really the core for the financial industry.
Right, and I think it's great that we are tackling this issue, but I'm a small business owner, and so for us, obviously our customers and their security is of paramount interest to us, and like smaller banking institutions, other types of retailers. So how can we make this in a way that's cost effective so that the smaller players, which often can't afford the compliance costs, a national standard, how do we come up with something that is affordable to them? Because what often happens is you come up with a national standard and then these people get left in the wayside, and then you end up with the collapse of the small business community because they just can't I mean, this is a perpetual problem in state government. I know when I was in state government, we just put these big one-size-fits-all regulations, and then we ended up with the loss of a small business community, which is really important to our area.
Yeah, that's a very important point, and I'm glad you raised it. And the discussion draft actually gets right to the heart of the cost question because, look, securing data is not a cheap proposition. And 3A, 2C reads the cost of available tools to improve security and reduce vulnerabilities.
Is there enough flexibility in this standard that would allow groups to, different retail groups or different sectors to get together in a way that they could provide for their own security and to manage the cost? Is that something that's been contemplated? And anyone on the panel can comment on that quickly if you have a question. Without violating any kind of federal standard, I know there's a lot of, obviously we're dealing with Social Security numbers, sensitive information, which is in there. Anyone have a comment on that? There's no way to make that so that they're able to be able to collaborate or come up with a retail institution.
I'm probably not the best person to talk about this, but the establishment of sector-specific ISACs is really the best way for companies to be able to share information, build relationships with government, and to prepare for breaches and then respond to them. And There's, we have them in financial services, energy, lots of different industries.
Yeah, there are several dozen ISACs in the country.
Right.
Financial services ISAC includes thousands and thousands of financial institutions in the country. The retail ISAC was stood up the last few years, again, to Mr. Creighton's point, to be able to share that threat information and help each other defend against cyber attacks.
Right, which I appreciate that, and I think that should be helpful. Obviously, it's sensitive information. One of the big concerns I have, this is a little bit outside of this space, is that we have the state governments typically don't have the ability and the resources to provide really adequate security and data. Do you think that that's something that could be done? So we have a national standard. What about the state governments requiring some of this data be turned over in the regulatory process? For example, the banking institutions, insurance institutions, and other retailers.
Well, we have many of those same concerns at the federal level because the bank regulators do expect tremendous amounts of very sensitive and proprietary information, for example, about financial institutions' cybersecurity programs to be turned over as part of the examination process.
I'm running out of time, but one quick thing, like for example, Congress gets hit almost every day, and government institutions are probably the most vulnerable. Would you agree or disagree?
Yes, ma'am, would agree with that.
Thank you so much. I appreciate your testimony. Thanks.
Gentlelady's time has expired. With that, we'll go to the gentleman from Michigan, Mr. Trott, recognized for 5 minutes.
Thank you, Chairman. I want to thank the panel for joining us this afternoon. And you know, one of my concerns when we work on data security and standards is a desire on the part of some to kind of set up, you know, gotcha moments. And if you look at the Equifax breach, you know, terrible set of facts. But it sure is, you know, provides good 30-second sound bites for people here in D.C. to attack Equifax, and they deserve that. Some of it, that's for certain. But one of my concerns, and I'd be interested in, Mr. Miller, your thoughts on whether either bill that we're looking at, you know, are the standards reasonable? And I know Section 3 of the chairman's bill says, you know, reasonably designed to protect individuals. I mean, if you start with the premise that no business or database, including the government, is beyond being hacked. You know, when I was in business, we used to hire brilliant high school students to figure out a way to hack into our firewall and our databases, and they always seemed to figure out a way to do it, and we spent a lot of money on trying to protect our data. But do you feel like there's enough flexibility such that some of these businesses aren't being set up to fail?
Thank you for the question. I think for the most part, there is a significant amount of flexibility in the security standards in the bill, and that's appropriate. I mean, as others have on the panel have said, it's really important that we don't be too prescriptive in our standards and require the same level or specific security standard for a large multinational corporation or, you know, the Department of Defense as we do for a small or medium-sized business or a startup. There are a whole bunch of reasons for that. You know, in particular, one of the good things about the list of safeguards in the bill is that they are consistent with a lot of risk management-based principles, and we certainly advocate for risk-based approaches. I think it's important that we also, when we talk about data security, we often talk about the protect function and that piece of the puzzle, and that's really important. But there is the reality that breaches are going to happen, so you need to be focusing also on how you respond and how you recover from that breach, and that is in the bill. You know, the one thing in the safeguard section that does seem to not really account for that sort of flexibility to us is the requirement to have, essentially to designate a security official who's in charge of the safeguards. Again, if you have a two-person startup, it's questionable whether you need to have the same type of mechanism as a designated security official at a two-person company or at a major bank, for instance. That would be the one thing I would say about that.
Yeah, I mean, the two-person startup, the designated person might also be, you know, cleaning the coffee pot out at night too, right? So that's a problem. One question, you know, this area is constantly evolving. So what kind of flexibility should we build into any solution to deal with the changes that are inevitable with respect to the technology and how consumers are using the internet and other places where they're putting their confidential information? Any thoughts would be helpful, because there's no question that today's safeguard is going to be outdated tomorrow when they figure out some other new and better way to hack into it.
Well, I mean, I completely agree with that. You know, we want to have technology neutral requirements. The point was made earlier about innovation and the fact that there are new security measures and tools being developed all the time, and that's obviously something that we need to do because the attackers are also innovating and coming up with new techniques. There are plenty of examples that we probably don't have time for now, but there are security technologies that were state-of-the-art 10 years ago that simply aren't state-of-the-art today. If you bake those into a statute and say you must use technology X, eventually that's going to be an obsolete statute.
All right, no question. Mr. Creighton, you, I think, mentioned the CFPB a few minutes ago. Can you just briefly comment on how the decisions by the CFPB and the FTC and other banking regulators have conflicted in this area? And maybe this was covered earlier by someone, but I got delayed getting here. But do you think that the UDAP authority that the CFPB utilized was even appropriate?
Well, in GLBA and in Dodd-Frank, the data security was specifically carved out of the CFPB's authority. And we would suggest that Congress would probably want to revisit that as the McHenry bill does, as the PROTECT Act does. But the CFPB does and always has maintained UDAP authority, and they are in the process now of asserting that authority and getting in there. And if they're in there, they're in there. We're not in the business of criticizing our regulators.
Yeah, okay, I'll do that for you, so no worries. Well, I think I'm about out of time, so I yield back. Thank you again for your time, gentlemen.
Gentleman yields back. We were without any further folks in the queue, so with that, we will wrap up the hearing. Just some closing comments. We're discussing today the ability to protect consumers' data. We also need to be able to allow them not only to be protected, we also need it to be accessible by them. And when we do that, it makes it very difficult to have both at the same time. This is where you can't lock it up and you have to be accessible to it, but that makes it vulnerable. So how can we protect the data? That's the trick. One of the questions that we're working here was throughout the discussion today was with immediate notification. I knew coming in this was going to be a discussion point, and I left it there intentionally to get everybody started and appreciate the discussion we had. But I'm a little disappointed because in the bill it says, the draft bill, that you don't notify until you recognize we had a breach, until you make sure that an individual person's information has been breached, you know who that person is, and where that person is something that information could cause a loss. So therefore, you're not notifying immediately when a breach occurs. You're notifying exactly whenever you determine that there is a reasonable expectation that the data that was breached was for an individual that could suffer a loss. And so I'm a little disappointed with the comments that were made. Obviously, everybody wants to have as much time as they can to resolve this situation, but I can tell you that this is a touch point for a lot of my constituents, your customers. They want to be able to protect their data as quickly as possible. I can tell you that when we put in there reasonable or expeditious, they're going to, somebody can drive a truck through, they're not going to be happy because they want to be able to have confidence that their information is going to be protected and they will have access to it and be able to protect it themselves if necessary as quickly as possible. So we want to work with you on that language to try and make sure this works. We thank you for your thoughtful suggestions along all the lines. Ms. Cable's made some great suggestions. We realize you've got a strong standard and we appreciate that. We have to find a balance somewhere in all this where we can be, as Mr. Credible continually said, flexible, scalable, and have some balance to what we do so it can be something that everybody all along the scale here can actually use this information and do something that we think is productive. I've been tasked with putting this bill together by leadership because of the thousands of breaches that have occurred. Ms. Cable's testimony indicated 28,000 over the last 10 years. I think it was 1,700 last year. Something has to be done. We're technically, I think, close to a crisis situation here, and quite frankly, we're one major breach away from this legislation being fast-tracked, quite frankly. So I think that everybody here today, I appreciate the large audience that we had. I think that we are all going to continue to work together to get this bill to a point where it's a good bill or something that we can address as much of the concerns, as many of the concerns that we can get to. Or it's going to be a very difficult bill to get everybody to yes, But we want to get to everybody to as neutral if possible and a yes. But we're going to continue to work with everybody, and we appreciate your suggestions. But again, I want to emphasize, we are one breach away from this being a bill that's going to be dropped, and we're going to run it because our constituents are going to demand it, and we're going to be in the crosshairs. So with that, thank you so much for your time today. Thank you for your testimony. We appreciate your participation. I've got some final comments. Here we go. Without objection, all members have 5 legislative days within which to submit a written question to the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witness to please respond as promptly as you can. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. And with that, the hearing is adjourned.